Hello guys, e don hot too. Nigerian government right now, they are confused as Nnamdi Kanu pledges 1 million naira for any Nigerian law student who can find judiciary precedent on stay of execution of accused, already discharged, acquitted person. You know say dem no go see am anywhere. You know say na only Nigeria then they bring out different things just to favor them. Kanu has been held in the custody of the Department of State Service DSS since July 2021 over an alleged terrorism charge filed against him by the Nigerian government. Anyway, guys, make I just leave you to watch this video. Hear what Nnamdi Kanu lawyer they talk, the way it arranged the matter. Right now, this is getting more interesting. Let me leave you to watch the video. Please don't forget to subscribe, don't forget to share, don't forget to like. Thank you.
Mazi Nnamdi Kanu offers 1 million naira to anybody, including students, who finds any judicial authority in support of Justice Tsunami in granting stay of release of an acquitted person. Mazi Nnamdi Kanu is offering 1 million naira to anybody who can bring any authority whatsoever to show that an acquitted person can still continue to be remanded in detention. Mazi Nnamdi Kanu pledges to give any law student in any Nigerian university, and indeed any other person, the sum of 1 million naira if such student finds any precedent on stay of execution in criminal proceeding where an acquitted person is by such order restrained from enjoying his freedom. It is an illegality that would haunt Nigeria for a long time to come. But then it was granted because Mazi Nnamdi Kanu is of the Igbo extraction and must suffer notwithstanding what the provisions of the laws are. And issuing a warrant of arrest, the federal government of Nigeria kidnapped and abducted Onyendu Mazi Nnamdi Kanu from Nairobi, Kenya to Nigeria in violation of Section 15 of the Extradition Act, therefore making it a trade now, a going trade in Nigeria, a very viable trade in Nigeria for kidnappers. And that is why we say that most of the kidnap we have today, they learned from the federal government of Nigeria. On the 29th of June 2021, the federal government of Nigeria produced Mazi Nnamdi Kanu in court, and in the absence of his lawyers and without affording Mazi Nnamdi Kanu the right to fair hearing, ordered that he be remanded in custody of the State Security Service, those who went to kidnap him from Kenya. On the 21st of October 2021, the federal government of Nigeria amended the charges to add the offense of terrorism, and Mazi Nnamdi Kanu pleaded not guilty to the counts or charges. His bail was and remained revoked. Mazi Nnamdi Kanu filed a notice of preliminary objection challenging his prosecution in violation of the Extradition Act, contending that his prosecution on the counts that existed prior to his extraordinary rendition was unconstitutional and abuse of court process and disclosed no offense known to law. The trial court agreed with Onyendu and struck out 8 out of the 15-count charge. On Onyendu Mazi Nnamdi Kanu's appeal to the Court of Appeal, the entirety of the outstanding counts of charge were struck out for want of jurisdiction, and Onyendu was consequently discharged and acquitted on the 13th day of October 2022. In an unprecedented manner and against all known laws, both locally and internationally, the federal government of Nigeria refused to release Onyendu from detention facility, and on the 15th of October 2022, the federal government of Nigeria filed an application seeking a stay of the release of Mazi Nnamdi Kanu from detention. This application was which is alien to Nigerian law and which never applies to cases of discharged and acquitted persons, was granted by the Court of Appeal, surprisingly, presided over by a panel of justices led by Justice Samani on the 28th of October 2022. Ladies and gentlemen of the press, this is a way and manner the case of Nnamdi Kanu is handled in a manner that no lawyer can explain, that agitates us, and we now ask, is Mazi Nnamdi Kanu being prosecuted or persecuted? In an attempt to arrive at a veritable answer to the above question, we shall address some salient issues pertaining the way and manner Onyendu Mazi Nnamdi Kanu's case is handled by the federal government of Nigeria. The trial court, illegally and in compromise arrangement with the federal government of Nigeria, revoked Mazi Nnamdi Kanu's bail. Onyendu Mazi Nnamdi Kanu did not jump bail and was justified in running out of the country to save his life and physical well-being. This is the finding and decision of the Supreme Court of Nigeria at page 11 to 13 of the judgment of the Supreme Court in case number SC 1361/2022. According to Justice E.A. Agim of the Supreme Court, it was therefore wrong and malicious for the appellant that has caused the respondent to flee from his home and country to secure his life and had therefore caused an unavoidable absence in court to inform and thereby deceive the trial court that the respondent jumped bail. On the basis of this deception, the appellant applied to the trial court for an order revoking the respondent's bail, forfeiting the amount securing his bail bond of his sureties, and an order issuing a bench warrant for his arrest. It is glaring from the record of proceeding in the trial court, and it is granted the said order in the trial court that it granted the said order prayed for by the appellant with knowledge of the fact that the respondent's absence from the court was caused by the invasion of his home by army officers of the appellant. Therefore, the trial court knew that the said extrajudicial and illegal action of the appellant made it impossible for the respondent to be in court for his trial, and the respondent's absence is not intentional or deliberate absence, and that the respondent is not running from prosecution or running to avoid prosecution. The order was made in the false assumption that the respondent jumped bail. See page 10 to 13 of the Supreme Court judgment. Revocation of bail was predicated on the trial court's interest and bias. In its judgment, the Supreme Court is in clear terms condemned the trial court in revoking the bail of Onyendu Mazi Nnamdi Kanu. According to the Supreme Court, after it held that the circumstances of Onyendu Nnamdi Kanu's escape did not amount to jumping bail, it stated thus: in the light of the foregoing, the trial court acted unfairly and without rational and legal justifiable reason by its decision revoking the respondent's bail, forfeiting the amount securing the bail bond of his surety, and its order issuing a bench warrant for his arrest. This is referred to in page 12 to 13 of the Supreme Court judgment. At page 19 of the Supreme Court judgment, the Supreme Court unequivocally held thus: this indifference of the trial court to these unlawful attacks on the person of the respondent and the extreme violation of his fundamental rights while he was in custody of law pending trial rendered the impartiality of the trial judge suspect. Even when it was glaring that the said attack on the home and person of the respondent by the official of the appellant made his further attendance of his trial in the case impossible, the trial court, rather than found that he jumped bail, revoked his bail and forfeited the bail bonds of his sureties, thereby victimizing the respondent. This is oppressive of the respondent and unfair to him. These are the wordings of the Supreme Court. The trial court ought to hold the federal government of Nigeria accountable for the absence of Onyendu in court and adjourn the case indefinitely until the federal government produces Onyendu in court instead of revoking his bail. It was the decision of the Supreme Court that the trial court did not do what the law expected the trial court to do in the circumstance where the federal government of Nigeria caused the absence of Onyendu in court by her Operation Python dance. According to the Supreme Court at page 19 and 20 of the judgment, it admonished in clear terms thus: what the trial court should have done then was to hold the appellant responsible for the absence of the respondent, order the appellant to produce the respondent, and order a stay of proceeding till the producing instead of granting the appellant's application for the revocation of his bail, and order him to be arrested as if he was running from prosecution. Onyendu was abducted and kidnapped from Kenya. The order of the trial court on the application of the prosecution was that the bail of Onyendu be revoked and the bench warrant issued for his arrest. In disregard of the procedure for arrest and rendition of Onyendu who was in Kenya, the federal government of Nigeria unlawfully kidnapped and abducted him in violation of international laws and his fundamental human rights. According to the Supreme Court at page 20 of the judgment, I quote again, in purported execution of the unfairly obtained and illegal order of arrest of the respondent, the officials and agents of the appellant traced the respondent to Nairobi in Kenya, violated his fundamental rights, kidnapped, abducted, and extraordinarily renditioned him to Nigeria without any form of extradition proceedings, without the consent of Kenya, in complete violation of the Kenya Extradition Act and the Nigerian Extradition Act and the African Charter on Human and People's Rights Ratification Enforcement Act, CAP A9, Laws of the Federation of Nigeria 2024, and produced him in court on the 29th of June 2021. In the light of the decision of the Supreme Court of Nigeria to the effect that Onyendu Nnamdi Kanu was kidnapped and abducted from Kenya, any publication, report, or statement referring to the blatant kidnapping of Onyendu as rearrest is deliberately, willfully misleading the general public, contrary to the ethics of journalism. We therefore urge our ladies and gentlemen of the press to act professionally and in accordance with law, and where necessary, correct the impression before the public. The continued detention of Onyendu is illegal and without the backing of any court of law. It is noteworthy that Onyendu's continued detention at the Department of State Security Service is illegal and not predicated on any court order. Recall that Onyendu was remanded on the purported belief that he jumped bail. By the decision of the Court of Appeal, all the charges for which Onyendu is being tried were quashed for want of jurisdiction and the violation of the Extradition Act of both Kenya and Nigeria. Justice Tsunami of the Court of Appeal, Abuja Division, unlawfully granted an order staying the release of Nnamdi Kanu. This order was illegally granted, and never in the history of any country's jurisprudence had an acquitted person been denied his release from detention by way of stay of execution. It has never happened anywhere in the world. Nnamdi Kanu offers 1 million naira to anybody, including students, who finds any judicial authority in support of Justice Tsunami's tsunami in granting stay of release of an acquitted person. Nnamdi Kanu is offering 1 million naira to anybody who can bring any authority whatsoever to show that an acquitted person can still continue to be remanded in detention. Nnamdi Kanu pledges to give any law student in any Nigerian university, and indeed any other person, the sum of 1 million naira if such student finds any precedent on stay of execution in criminal proceeding where an acquitted person is by such order restrained from enjoying his freedom. It is an illegality that would haunt Nigeria for a long time to come. But then it was granted because Nnamdi Kanu is of the Igbo extraction and must suffer, notwithstanding what the provisions of the laws are. On the part of the Supreme Court, Onyendu Nnamdi Kanu did not jump bail, but rather ran away from the treacherous acts of Operation Python Dance to save his life and physical well-being. At page 10 and 11 of the Supreme Court findings and decisions, it was held that the respondent was on bail and therefore in the custody of the law when his home was illegally invaded by heavily armed military officers of the appellant, causing him to flee from his home and country to secure his life. In the face of such an attack, it was reasonable for him to flee to secure his life and physical well-being. That is what any normal and reasonable human being would do in that circumstance to preserve his life and physical well-being. The High Court in Enugu State, in suit number E20/2023, between Nnamdi Kanu versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023 by Justice A.O. Onovo, in the enrolled order of its judgment declared thus, that the practical application of the Terrorism Prevention Act and the executive or administrative action of the respondents, which directly led to the proscription of IPOB and its listing as a terrorist group, said IPOB being comprised of citizens of Nigeria of Igbo and Eastern Nigeria ethnic group, professing the political opinion of self-determination and the consequential arrest, detention, and prosecution of applicant as member/leader of the said IPOB is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right not to be subjected to any disability or restriction on the basis of his ethnicity as enshrined and guaranteed under Section 42 of the Constitution of the Federal Republic of Nigeria, 1999, as amended,